May it please the my ladies, I appear for the claimants. With me are Kevin Paulwell and Tamara Mason, and we are instructed by Hilton Paulwell. Learned friend Alan Wood, King's Counsel, and with him Nico Pagan and Catherine Williams, instructing by Divinton Alexander Mealy, appear for the defendant. My ladies, I have been asked to apologize for Mr. Brown, King's Counsel, who is traveling today. My ladies, the first claimant is present in person. The second claimant, I apologize for his absence, he couldn't be here, but he's represented by the deputy leader of opposition business in the Senate, Senator Scotland. And finally, my ladies, Learned and Dwayne Green are watching proceedings for the office of the director.
Very well.
Those are the appearances.
Thank you, King's Counsel. We're gathered here today for the delivery of the decision in the matter of Phillip Paulwell et al. And the Attorney General of Jamaica. King's Counsel having announced the representation, we will now get into the reasons for our decision. We will commence with the issue which the court had to decide, and that was whether sections 96(1) and 121(1) of the Constitution of Jamaica were validly amended by the Constitution Amendment of Sections 96(1) and 121 Act 2023, which we have referred to in our judgment as the Act. The facts in brief, which we have found, are that in July 2023, the Act was passed after a majority vote in both Houses of Parliament. The Act now contains Section 2.1, which increases the age of retirement of the DPP, and Section 2.2 is a new section, which gives a right to the DPP to elect to remain in office despite the role of the Prime Minister and opposition leader regarding an extension of tenure. This right applies to a DPP who is 60 years of age. The incumbent DPP was born in 1960 and had reached the retirement age of 60 under Section 96(1) of the Constitution. In January 2020, the DPP requested an extension of tenure. The Prime Minister initially proposed a 5-year extension, and the Governor-General approved a 3-year extension, which expired in September of 2023. In February 2023, the DPP sought another extension, which was declined by the Public Service Commission, referred to in our decision as the PSC. That refusal was in May of 2023. The PSC then cited constitutional limitations on the grant of a second extension, as well as the refusal of the Prime Minister to grant the extension. Following the PSC's decision, the Act was passed. In response, the DPP submitted a letter to the PSC electing to continue in office until the age of 65. The PSC approved a 2-year extension from September 21, 2023, and recommended that the Governor-General appoint the DPP. His Excellency made the appointment based on the PSC's recommendation. It was argued before us that, by the claimants, that the amendment is unconstitutional and should be struck down on the basis that the current DPP has already received 1 extension in office and should not benefit from the Act which seeks to grant a second extension. The incumbent would benefit from a de facto extension in a manner not contemplated by the Constitution. In addition, the claimants contend that the Act bypassed the legal process for extending the DPP's retirement age, effectively usurping the powers vested in the Governor-General and the opposition leader. In support of their position, the claimants exhibited evidence of the debates in Parliament. The defendant argued that the Act was passed in accordance with the manner and form required to amend the Constitution and is therefore valid. The defendant asserted that Parliament holds exclusive jurisdiction over its internal affairs and the court cannot interfere with its procedure. The defendant submitted that neither of the Houses of Parliament had authorized the the claimants to present evidence of parliamentary proceedings in court, and therefore such evidence cannot be considered as provided by Section 11 of the Senate and House of Representatives Powers and Privileges Act. We now move to the decision of the full court. This court has ruled that Section 2(1) of the Act is constitutional. Section 2(1) of the Act has amended the Constitution as regards the retirement age of the Director of Public Prosecutions. A new provision introduced into the Constitution by Section 2(2) of the Act grants the DPP the option to remain in office after age 60, and this gives the DPP a level of authority not envisaged by the Constitution's framers. Section 2(2) of the Act is not a valid section and is severed from the Constitution because the process remains unchanged for extending the retirement age. Section 2(2) is unconstitutional, null, void, and of no legal effect. On a proper interpretation, Section 11 of the Senate and House of Representatives Powers and Privileges Act did not prohibit the claimants from exhibiting the proceedings in Parliament. The reasons for our decision are as follows. The incumbent DPP has already reached the extended retirement age. This means that the application of Section 2(2) cannot lead to another extension in office by way of an election on the part of the incumbent DPP, as this is unlawful. Section 2(1) of the Act, as currently formulated, has raised the retirement age without addressing the extension of tenure in office. Consequently, any extension of the DPP's tenure under this section must adhere to the same process outlined in the previous Section 96(1) of the Constitution, which remains unchanged by the Act. The only lawful method to extend the DPP's tenure remains by way of an agreement between the Prime Minister and the opposition leader. Given these considerations, there is no necessity to delve into the application of Section 2(1), nor does it require reading down. Section 2(2) of the Act is the offending provision, and the court holds that it is incompatible with the Supremacy Clause. In light of the foregoing reasons, this court orders as follows. Judgment is entered for the claimants. This court declares as follows. 1. Section 2(1) of the Act is a valid constitutional amendment. 2. Section 2(2) of the Act is an invalid constitutional amendment. 3. Section 2(2) is severed from the Act and is struck down and declared as unconstitutional, null, void, and of no legal effect. The parties may write and file and exchange their submissions within 7 days of the date of the orders made herein. On costs. In addition, the decision on costs will be heard on paper. We'll now hand down the decision, Mr. McCarthy.